Hi, I'm Annette Pinyazic. I'm the Director of Grants and Major Gifts for Houston Area Parkinson's Society. And today, thank you so much for joining us. This is our fourth HAPS Estate Planning Education webinar. And we've been fortunate each time to have Kathleen Wiesenthal presenting. And we launched this series in response from our community members who were asking questions about estate planning and if we had any ideas for doing any educational programs about it. And Kathleen has been very generous with her time and has presented. This is our fourth of four webinars, and Kathleen is with Kiever and Wiesenthal, and her practice focuses on probate, real estate, and estate planning. And today she's going to tell us all about probate, or at least a little bit about probate, what she can fit in today's hour. Now, we have reserved some time for questions and answers after Kathleen's presentation. So you can add your question, any questions for Kathleen at any time using the Q&A function, and we'll get to those all at the very end after Kathleen has done her presentation. Now, today's webinar is being recorded. We will have a link for it available on our haps.org website and also on our HAPS YouTube channel. Give us a few days or up to about a week or so before that goes live. If you'd also like a copy of Kathleen's presentation slides, just let us know. All you have to do is hit reply on this Zoom link and request the presentation, and we will send those to you. So thank you, Kathleen. I'm going to pass everything over to you and let you get started. Thanks,
Great.
everyone.
Thank you. Good afternoon, everyone. It's so good to see you. I hope that you are safe from the rain and able to hear me. If not, like she was saying, there will be links so that you will have the ability to get copies of what we're working on. Hold on just a second. I'm going to share and I'm going to share. Today, what we're talking about is probate itself. Why do you want to do a probate? What's involved? And what does probate actually mean? So let me start the slide program for you. Okay, hopefully you have some nice green grass to look at, something kind of relaxing, because probate should not be a horrible situation. You should be able to be very comfortable with probate and get yourself an attorney who can help you through the process. Probate is not something you can do without an attorney. And the reason is that if you're going to be in court proving up an estate and or trying to probate a will or an intestate estate, which we will define in a few minutes, then you are not representing yourself, which is like when you go to court for a traffic ticket, you can represent yourself pro se. In probate, you're not representing yourself, you're representing the estate. And since you're not an attorney, you can't represent the estate without an attorney working through the process with you. Plus, it's really complicated. So you don't really want to do that. Let the attorney do all the hard work. All right. So one of the questions people ask is, well, why do I have to do probate? A lot of people get very upset because they think that it's a terrible process and it's lengthy, and oh gosh, why do I have to do that? Well, in some cases, you may not have to. But if you have to, let's make sure that your estate plan has given you the tools up to the point of your demise and given your family the tools to be able to go as smoothly as possible through the probate process. Probate is necessary and can only be done when someone has died. I swear that's not meant to be facetious. A lot of people actually ask me that. When someone has passed away, you have to take care of their estate administratively. When you, I know there's a lot of expenses involved in somebody passing away. There's funerals and there's interments and there's cremations and there's the party and the limo and all of those things, and they all have to be done within minutes. Practically, it seems like that when someone passes. The probate process gives you a little bit of breathing room. The probate process is takes the clock starts ticking when the decedent has passed away. And then you have 4 years with which to decide what you're going to do with the probate itself. Now, let me go to the next slide and let's talk about some terminology in the, hold on. Why is it not moving? There we go. Vocabulary for some of the things we're going to be talking about. A decedent, you probably already all know what that means. It means the person who has passed away, and their life has to be somehow administratively dealt with. Their financials, their legal assets, sometimes there'll be some medical involvement, and there's creditors. Everything that involves that person, they are the decedent, and their estate are all of the things that they owned at the time of their death. If a person dies with a will, it's called testate. And therefore also comes the word testamentary. If somebody has a will, we consider that a testamentary gift to the beneficiaries. And when you hear that term, that means there was a will, if the term is being used correctly. And that's what the court issues to people. You may have heard of the phrase letters testamentary. That's what the court will issue to an executor who has been named in a will and is available to serve and qualifies as an executor for an estate to handle the estate affairs and to execute the will. In other words, to make sure that everything that was requested in the will is taken care of, issued, beneficiaries get theirs, their assets, and any questions or things that aren't resolved have to be handled by the executor also. Intestate means you didn't have a will. Okay. Now, testate could mean a typed up will by an attorney, signed and witnessed and notarized. It also could mean a holographic will. And a holographic will is a will that you write in your hand, which can be considered um, uh, completely valid. And it's helpful that if you're going to handwrite a holographic will, which means it's all in the testator's handwriting. Nobody else can write that up for you and then you sign it. It has to be in your handwriting, has to be dated. It helps a lot if you designate an executor, and it also helps to completely name the people that you want to be beneficiaries. Don't just put my son, because that helps nobody. So, and so in those don't fall into intestate because you actually made an effort, and the court gives you credit for making the effort to put together a will to dispense with your estate, and they respect that. Intestate means you did absolutely nothing to set up your estate, or you did an invalid will, and that can be considered intestate. There are millions of invalid wills, one of which is a fill in the blanks will. If you've got one, go get another will because those are not considered valid wills. And you can't have a will that's handwritten by somebody else and signed by you. That's not valid. You would then have an intestate administration. Administration means that somebody had to come forward with standing, and we'll talk about standing, Somebody has to come forward and say, I'll probate the estate, I'll pay for it, I'll take care of it, I'll try to qualify for that. And you have to go through heirship for this. You have to get in touch with all of the heirs that would have received assets, and it could either be a dependent or an independent estate. Again, I'm just throwing these vocabulary words at you right now so that you can understand that each of them have a very specific meaning, and that we will talk about those meanings as we go through these slides. Now, if you're testator intestate, that's going to depend on whether or not you have a valid will. And if you don't, your attorney is going to be able to walk you through what the next steps are. If it's testate, and I have that on another slide later on, having a will is the easiest way, as long as it's self-proved, has two disinterested witnesses, they all signed in front of each other, and the notary signed, or was at least present when the testator signed. All of these are very, very important things. It requires what they call the solemnities of the statute. And that's to guarantee, it's not to be a trouble for people to do a will. It's to guarantee that people that are preparing a will are being held to a high standard so that third parties can rely on that will to dispense with their assets. And we also hope that it helps prevent fraud, or at least puts a stone wall in the way of fraud or undue influence. So that's one of the reasons why testate and having a will is very, very important. That process is very easy. It takes me 4 to 6 weeks to get a will through the probate courts. On intestate, you're going to have heirship done. You're going to have to declare who the heirs are of an estate. When you have a will, you're saying who your beneficiaries are going to be. When you're intestate, nobody has a clue in the courts or in the government themselves about whether or not you have any heirs, and if you do, who they are. You have to name them and do research to find out who those people are. We'll go into that a little bit more. So that's expensive too. It costs more because you have to actually have two hearings, one for heirship, one for administration. And then somebody that wants to just step up and help with the probate or wants to help move it forward, they have to have standing. And standing means that in the probate code or in the estates code, you have got to make sure that you have the ability and the bloodline to be able to step in, or that you're an appropriate person to step in as an administrator on a particular probate and a particular intestate succession, and that there aren't other people who are more qualified. And if there are more people who are more qualified, we're going to get them to sign waivers and consents for you to serve instead of them. The character of the assets involved is very important. The character of the assets, we're talking about whether it's a vehicle. If it's a checking account, which is held by a bank or a credit union, if it's a brokerage account held by Edward Jones or Merrill Lynch or something to that effect, or Morgan Stanley, I think is one of the better ones. I don't think Merrill Lynch holds people's money anymore. Um, and if those assets are real property, they're dealt with very differently than the checking accounts and brokerage accounts and vehicles. All of these things have to be dealt with differently. The good thing about estate planning is your planner, your attorney who's putting that together, can make arrangements in advance to help you move those assets through to the beneficiaries ahead of time. And if not ahead of time, at least simply and cleanly at the time of death. multiple marriages and stepchildren. I got to make this point to people because it's very important that you know that if you have if you are on a second or third marriage, you have children by a marriage other than the one you're in right now, or your spouse has children and they are not your bloodline, but they are your stepchildren. Um, when you pass away, your estate, if you don't have a will, does not go to your spouse. It goes to your children, either outside the marriage or also in the marriage. I mean, if you have two children in this marriage and one from outside the marriage, your three children are going to inherit your estate. The not everything. I mean, there's some breakdown on that too for personal property, but um, if you've got a mixed family, you've got to make sure that you've done something to make sure if you want your spouse to have anything, to make sure that they get that. It's not automatic. And all of the spouses out there who are thinking that when their spouse passes, that everything goes to them, that is not the way it works. And you have got to be careful because you may have a house that half belongs to your stepchildren and have no way to sell it because the stepchildren aren't speaking to you, those kinds of things. That's just an apocalyptic kind of a scenario, but you want to make absolutely sure you've got those things taken care of and that your spouse has that taken care of. Don't let it go, okay? The costs and time factors, I'm going to have a slide that will talk about the different costs and how they differ between testate and intestate. All right, testate, as I said, means you have no will. I'm sorry, have a will. Forgive me, boy, that was confusing. Testate means you have a will, or the individual has a will. Intestate means there was no will, or you can't find the original will. That also can be considered intestate. That's a problem. And that's another slide all to itself later, which I don't even know if I included it because we only have an hour. Um, so that's again, those I wanted to burn that into your memory so that you understand that those are very, very different situations when you go to probate and estate. Okay. Testate again means the decedent had a will. It was self-proved, which means it was signed. The testator signed in front of the witnesses, and a notary was present when the testator signed, and that everybody can say, yeah, I was there, I watched him sign, I signed. The witnesses have to be over the age of 14, the testator has to be over the age of 18 or married, one or the other. And so it's a solemn little ceremony you're going to go through when you prove up a will, when you've signed it and you've had the opportunity to review it. It's something that's taken very seriously because it has legal ramifications. That document, a will does not become a legal document, however, until it's been entered into the court. So I've had a lot of people come to me and say, my mom left me the house. And I said, okay, where? In her will. Well, okay, did you probate the will? Oh, no. Guess what? House isn't yours, and it's been 6 years. And that's another thing with having a will. You have 4 years to probate that will, but then the executor no longer, maybe, depending on the court and the attorney that you've got representing you, you no longer have the ability to be an executor, an independent executor. People can contest your being an executor and bringing a will after 4 years. And boy, they stick to the 4 years. If it's one day after the 4 years of the person's death, that court will not accept it as an independent executor. So you got to be very careful, make sure you have an attorney on top of it. A holographic will we talked about is the kind that is a handwritten will, all in the handwriting of the testator. Date, saying that it's your last will and testament, stating who you want to be your executor, stating who you want your assets to go to, and then sign it. You don't have to have it notarized. You don't have to have it witnessed, but at least include those bits of information so that the will, we can actually do something with the will. If it just says, um, you know, to whom it may concern, I want my daughter to have everything. That's it's really bad. As you can see, I'm blinking my eyes like, no. The whole idea is you have to name the people, you have to appoint an executor so somebody knows who can take that will to court. There's ways around these things if somebody neglected some of these details, but you really don't want to have to go through that drama. And it does cost you more attorney's fees when you have to do that. And let me see, I think that's it on that one. Intestate, again, when you have no will, what happens is there's no executor named to be appointed to represent the estate. Therefore, somebody has to step forward. So, for instance, if my father passed and my mother, um, and he didn't have a will, my mother could step forward to be the executor of the will, or I could, or maybe even my children could, um, and or my siblings, things like that. So anybody with standing who has an interest in the estate could step forward to be the appointee for as they can't be an executor, but they can be an administrator, which has a little bit less power and it leaves you relying more on your attorney at that point. All right, court or county involvement. Either way, when you have when you're trying to handle somebody's estate administratively, it has to be handled either in a courtroom or administratively through a county. Okay. And now there could be other ways too that an estate would be handled, but these are the two that I come in contact with about 98% of the time. A will must be entered no later than 4 years after the death of the testator. If you wait for over 4 years, the court will not enter the will unless your attorney can talk the court into it by presenting to them some evidence that you didn't purposely withhold the will. But you still have to get approval from all of the other possible heirs. So if you are getting grandma's house, but grandma had 20 heirs because she had 8 kids and they each had kids, we have to sit down and put that all together and get those people to all agree that you can file that will after the 4 years. And if they don't agree, it becomes a dependent estate. Nobody wants that because that's very troublesome. That means the whole estate is going to be governed by the court. When you talk to people and they say, oh, probate's a nightmare, that is probably the situation that they've had to talk about. It's a very troublesome thing when people don't take care of their business before they pass away and prepare wills, because then it's a kind of a free for all, but it's not. But it's so contentious, and so many people react poorly to death. They grieve, and while they're grieving, they're taking it out on somebody who treated them bad when they were 15. It's a really good opportunity for the testator to make sure that this will not happen by making sure that you've done the will, and then making sure your executor knows they have to file that will, that they can't just sit on it. A will is not a legal document if you're sitting it in a drawer. That original will has to be filed with the county in order for it to at least be the beginnings of a legal document. You can file a will in the county ahead of time if you before your death, if you wish. And then you just have to let somebody know that that's there. A good attorney is going to search and see if that will is of record already. And if not, then they will ask the family for an original will. And if the family can't find an original will and you have to use a copy, that's a whole nother slideshow. So we're going to stick with the fact that we're going to hope everybody saved the original safely and we're able to give that to the court for the probate itself. Assets that are involved, we were talking about the character of the assets. If there's real property involved, for instance, grandma has no money to her name, really, but she has a lovely house that is paid for, and she wants very much for that property to go to someone in her family. There's another way to do that. Besides, I mean, I still want grandma to do a will in case there are any other assets that you don't want anything to become intestate. You want there to be something that gives direction to the court or to the executor who gets all of your assets. But real property can be handled outside of probate very easily. And I'm going to go to that in a minute. Liquid assets such as cash, CDs, brokerage accounts, um, things that you could probably turn into cash very quickly after someone has passed, or at any point. Those liquid assets are handled differently. If you are making sure to have beneficiaries payable on death or joint tenants on any of your checking accounts or on your brokerage accounts, you can probably avoid frozen bank accounts when it comes to the estate. And then you've got money. If somebody hasn't already taken care of everything, you've got money to pay for the funeral and pay for the bills of the household that you still have to keep up and things like that. Again, I'm shortcutting through these items, not because I'm trying to shortchange you, but because these are topics all on their own. And I just want you to make you aware of them. So if you have real property, see an attorney. How should you set that up so that it's easiest for your family? If you have liquid assets, see an attorney, find out what's the easiest way. Or I can tell you right now, go make sure that your assets have beneficiaries listed on them. Go to your place where you do the business with these people or go online and make sure you've got beneficiaries. And if you say, oh, yeah, I did that 10 years ago, go check again. Okay. Because there are human beings who work on these assets, and sometimes they don't, your beneficiaries may not make it with your file. Vehicles, there's ways that you can handle taking care of vehicles ahead of time before you're passing away. You can actually, like if you have one nephew who's dearly in love with your old classic vehicle, you could give it to them ahead of time by signing the back of your title. They don't have to take it away from you right then and there, but once they've recorded that title, then they would be responsible for insurance and things like that. But in the meantime, if you only wanted that nephew to get the vehicle, then we can help take care of that too. Household and personal property, most of the time families consider that negligible and they don't make much of that. I would like people to rethink that, because if you don't want the family coming in and picking through your things, and some of them inequitably taking things a little bit more because they got there earlier than their siblings, you really want to stop that by perhaps making a list of personal property that you want to give to certain people, or give it to them before you pass, or in your will you can actually stipulate who's going to get what. If, for instance, you're leaving your real property to your nephew or to your children, You may also, I would suggest that you make sure that you put in there that the household and personal property goes to the person getting the real property. That may not be the way you want it, but those are the kinds of things that you have to address to avoid hard feelings and fighting amongst the surviving people who are going to be beneficiaries. And again, who has standing to initiate a probate? The Any bloodline family have the ability, and any half siblings or adopted parents, of course, always have the standing to initiate a probate. Your neighbor can't, and your son's girlfriend can't. Um, your second husband um, does. Your second husband does, even though none of the children may be his. Um, and if you have um, uh, a wife that is still married to you at the time of your death, they have standing to initiate a probate. So those are the things that you would want. It's more on an individual basis that you're going to have to answer those questions. But in other words, you can't just walk into somebody's life and take over and say, I'm going to do their probate, because that is not cool. Who gets the assets in a testate estate? This is an easy answer. It's the beneficiaries. Beneficiaries are people who are specifically mentioned in a will. If their names aren't mentioned, they may be a part of a class of beneficiaries or a class of heirs that someone puts in their will. For instance, if I say I want all my children to get all of my assets and distribute them equally, that's the beneficiaries. They get all of my property then. And if I list my sister, I'm going to give her $20,000. Then the sister gets 20,000, and my dog goes to my brother. And these are the kinds of things that um, are laid out in a properly prepared will. Okay, if you have an intestate estate, the heirs will probably get your property. It depends on the character of the asset, once again. And very often the spouse doesn't get the assets if those assets are separate property. For instance, if the wife inherited money, put it into an account with only her name on it, and that inheritance would then be separate property. It would stay separate property if she never commingled it with her spouse. So when she passed away, her children got that account or money or property, real property, not the spouse. The spouse may get a life estate in a piece of property, but that's all they get. And the actual legal title to any of those separate property assets will go directly to the children. The spouse is not automatically ever an heir. It doesn't happen by magic, which is my next. There's actually, I'm going to skip forward just a little bit. If you don't have a will, remember, no assets magically go to your heirs. That is not a thing. And no assets magically go to your spouse. I have a lot of women who walk in and say their husband died and I own the house. And I say, well, did he have any children outside the marriage? Oh, sure. He had 4 children in, Ecuador. And I'm like, well, his 4 kids in Ecuador are own half that house and you own the other half. That's very upsetting for people when they hear that. And again, it's because there was no will done, nothing was done about, and you can't do anything about it. Legally, at the time of that spouse's death, that half of his half of the property went to those children. The wife is going to have to own that property with them. Therefore, she can't get money on it to refinance it. She can't sell it without the kids. And she'd have to involve the kids in the decisions that she makes. And at the same time, she still have to pay the taxes, has to pay the HOA fees, etc. So those are the kinds of things I want you to be aware of. Again, I can't go into a lot of detail just in the time that we have, but I want you to be aware that this could be an issue and you probably should go see somebody about that. Now, let me see how I get backwards. Nope, that's not right. Forgive me for a second while I go back to the slides and find my, there we go. Okay, so sorry. All right, costs. Costs are important. A lot of people think it's incredibly expensive to probate an estate. Every attorney can set their own price for what they're going to charge you to probate a will or probate an estate with an heirship. Um, I I have my flat fees that I charge. I do not charge by the hour. So you might want to find an attorney if it's easier for you to not be in doubt. Find an attorney who maybe does a flat fee, or can you make sure you have an engagement letter with the attorney no matter what, that tells you exactly what your money is going to be going for and what services, excuse me, what services are going to be paid for by you retaining the attorney. Um, when you go through a county court, you are paying for the fee for the attorney representing you. If you do not have a will, you are paying for an attorney ad litem. If you have a will or not have a will, you're paying for filing fees. For instance, it costs anywhere from like $336 in Harris County to file a will. And it could cost you up to $480 to file a will and an heirship. Those are the county fees so that they get their money for forwarding all of the paperwork through the system and into the courts. An intestate administration will have to have an attorney ad litem. What that person is an attorney appointed by the court, and that attorney represents any unknown heirs. And the reason that it's in an intestate estate only is because in a will, your testator has already named the beneficiaries. It's not necessary to find out who the other heirs are because the testator isn't leaving them anything. You've already got all your beneficiaries in that will. Switch sides and go to an intestate administration. If they haven't done a will, you have no idea who's supposed to be getting their estate. There is a statutory regime of who should get their property. And the attorney ad litem, it's their job as a court appointee to go and find out who the heirs would be according to the statute, and that's in a nutshell what that means is your children would be your immediate heirs. And this here that I'm going up and down with, this is a timeline like when you're doing ancestry.com, if you're doing a family tree. So you're going to go down first to the children. If there are no children, or if you have some deceased children that had grandchildren, then it goes to the grandchildren. And if there are no children for somebody that's passed without a will, it will go up to their parents. If their parents are deceased, you're going to go over to their brothers and sisters, aunts and uncles, cousins, and that's how it goes. In other words, people say, well, I don't want the state to get my property. The state doesn't want your property. They want it to go to an heir. They will make sure, and it's a lawyer's job to make sure that that estate is going to go into the hands of the heirs who are entitled to it. And again, that depends on a few other things, but it's something that you definitely want to be very careful about. The Oh, and you have to also have two disinterested witnesses. Hold on just a second. I'm so sorry. You have to have two disinterested witnesses who are going to be testifying as to their personal knowledge of the family and marital history of the deceased. You will have to, those two witnesses have to have known the deceased at least 10 years and be familiar and would have been very familiar with family and marital history. It helps if the witness knew them for 40 years, but that's not always possible, especially in this day and age when people move and change, homesteads and things like that. The disinterested witnesses are usually not blood relatives, and they cannot be getting any kind of benefit from the estate, which means that they're not an heir by definition under the statute. A probate can also be done, or it's not a probate so much, but you can help resolve an estate, at least when it comes to real property, through an affidavit of heirship. Um, there are some documents that somebody can prepare. It's called the transfer on death deed that someone can prepare to give their property to someone, and it is effective upon the person's death. An affidavit of heirship is when there has been no preparation like that. But if you have mama died without a will and you have 8 brothers and sisters, you can prepare, or your attorney will prepare for you, an affidavit of heirship that lists all of the children, addresses, birth dates. If any of those children are deceased, it lists their heirs. And so a piece of real property can be owned by all of the heirs to that decedent. And again, state doesn't want the property. They're trying to give it to the people who were part of the family. You do have to have that prepared by an attorney. I have seen people try to prepare their own, and it's frustrating because it may not have the legal authority that you need it to have in order to sell the property. Ultimately, you're going to want to sell a piece of property, or one of the family members is going to want to, pay everybody else for that property, and they want to have a clean title. They want to be able to move into the property, and especially if it's outlying property that's just land or undeveloped land. So this is a way to make sure that we list all of the heirs that are appropriately um, legally part of this property, and then the people that are the heirs can deal with this whatever the way they want to. If they buy it from each other, if they just own it forever in perpetuity and just have their kids own it. As long as somebody's paying the taxes, you can own it as a group of heirs anytime you want. The again, that affidavit also requires 2 disinterested witnesses that are going to sign an affidavit under penalty of perjury that says that they believe that these are the only heirs at this point in time. Now that will change. Let's say all 6 kids are living, and at the time that you prepare the affidavit of heirship, that gets filed in the real property records of the county that the homestead or the property existed in. Um, let's say that about 5 years later, the kids want to all sit down and decide what to do with the property. And if somebody else has passed, you actually, if they don't have a probate or a will, the people that have passed away that were part of the heirs, then you're going to have to do something with their estates. And then maybe do another affidavit of heirship showing that John, who died a few years after doing the affidavit of heirship, had 5 kids. So you've got to do something that shows that John's 5 kids are the heirs to his property, because inherited property is separate property. It does not go to the spouse except under very unusual circumstances. So you've got to be sure that you've taken into consideration all of the things, especially if it's even just for your brothers and sisters. You want to make sure they've got their acts together and left the wills and things like that. If that separate property was addressed in a will and they ended up giving it to their wife after all, because the wife is not usually the one who's going to receive separate property, then you at least know who the next person you have to negotiate with on that property is, and then you are all part of that property. That it also has a name to it called heir property, HEIR. Air property can be handled, actually, there's a legislation that lets it be handled in the courts, and you're not blackmailed or beholden to one or two people and can't do anything with that property. You do have legal recourse if you need to make some um, progress on the property with some of the owners. All right, probate timing. Probate through a county court in Harris County um, takes 4 to 6 weeks for a will. I can push, we have 5 statutory probate courts in Harris County, and it takes me about that long to go all the way through to get a hearing for a will. Very simple process. Sometimes, if I've prepared the will, I can even represent the executor at the hearing, and the executor won't have to be present. Obviously, the courts prefer that they were, but if it's impossible for the person to do that. In Harris County, and I think in Montgomery County, um, sometimes in Fort Bend County courts, you can do everything by Zoom. There are some outlying counties like Galveston County, no Zoom. You have to go to court. You actually have to show up. Um, and so that takes a little bit of extra time. For an intestate administration, it could take anywhere from 4 to 6 months. The reason that it's so long is that you're dealing with a whole bunch of cats that you have to herd. So you've got two witnesses. You've got to get them on board for everything. You've got an ad litem who's working on their own schedule. You've got your my client who's actually going to be doing the administration of the estate. You've got the court who has an agenda of their own, and they want to make sure that everything that you're doing comports with the estates code. And it may sometimes, just because those hearings take a little longer, you may not be able to set a hearing for that for 2 months, 3 months after all of these other people are pulled together. Then you can ask for a hearing, and it may be 2, 3 months down the road before you can do that. So it requires patience. Probate through the affidavit of heirship, it really depends on who's giving the information to the attorney to prepare all of this. If the attorney has all the information they need, then it can be done pretty quickly, and it can be done very thoroughly. In a perfect world, should only take a week. If the witnesses are available to talk to and make sure that they're vetted, to make sure that they're able to sign that affidavit. Um, if the affiant who's trying to set up the affidavit of heirship doesn't have any of the information and your attorney has to do the research, it's going to be more expensive and it's going to take longer because the attorney's going to have to do all this research on their on their clock. So it's definitely something to think about. Um, Please choose to transfer some assets before you pass away. It sounds weird. I don't mean today. You don't have to start giving your stuff away, but you do want to think about that as one of the options. Instead of just putting it all in a will and waiting for somebody to give it to someone, you could take care of it ahead of time. And again, it depends on the character of the asset. For instance, you don't want to give anybody your checking account because it's not time yet. They can deal with that later. And you also want to think about what tax implications there might be for the beneficiaries, and that a lot of that has to do with real property, and it could also have to do with like a 401k. You might want to check in with a CPA about what tax implications would be. Again, it's not magic. It happens with hard work, and you need to have an attorney. Be patient with that attorney because They're dealing with a lot of people and pulling them all together to make this happen for you. And be very honest. Do not leave out the half sibling that you don't like, because that has legal ramifications and that's a lawsuit later. You don't want to do that. Don't try to save money. I have somebody that I swear to God, just called me yesterday and they were trying to save money and not do a probate. And now they're stuck with a house that they don't own. And they've been paying for it for a long time. And they could have legal ramifications for their lack of attention to the quality of the home. So we want to be careful. Um, and let me see. So the heirs, the executor of the court. Again, it depends on the people. That last comment, the amount of time a probate takes depends on the heirs, the executor of the court, and the ad litem. You have a lot of people who are involved in this process, and it's your attorney's job to make sure it all comes together. It's nice and neat, all ready to go in a beautiful package with a bow on it to go to court and take it to the judge. So all the judge has to do is say, I appoint you as the executor. I appoint you as the administrator. Those are beautiful words. If your attorney's worked hard, that's where that goes. And that's all I have for right now. If you have any questions, I am very willing to answer them.
Thank you so much, Kathleen. That was a lot of information, wonderful information, and very appreciated. We have quite a few questions, and one that I'm going to start with that someone asked, I'm going to ask if they could send in a specific question they wrote in, and they wanted to know if you could go back to the slide that was on cost and timing and discuss again. Unfortunately, I don't think we have time for that one.
Mhm.
So, in that, but if that person has specific questions, please submit it and we will try our best to get to it. Um,
Absolutely.
so, first question, can you please explain the spouse not receiving your estate? Does that mean just for a second or third or more marriage, or does that apply to the first marriage?
Yeah, let me get my cheat sheet. So, for instance, if a married person does not have children or does not have a descendant and they pass away, everything they have for separate personal property goes to their spouse. Real property, however, will go half to the spouse keeps their half of the house because it's always 50-50. Only if the spouses bought that property together. So, when you're talking second and third marriages, you could be living in the house he bought with wife number two or wife number one. And so you got to be careful who owns the other half of the house with your spouse. And it's going let's say it's a him and he has passed away. If he doesn't have children, then we're going to go up to his parents, and his parents will own that half with you. Or it might be, again, if he has children, then his children are going to own that house with you. It's not automatic that a spouse gets a piece of property, because when you buy a property with a spouse, you are only getting, according to Texas community property, you only have a claim on half that house, unless you have a deed that says joint tenants with rights of survivorship. And this is considered, well, it doesn't even have to say community property because that just messes it up. But unless you say joint tenants with rights of survivorship. And what that means is that my husband and I buy a house together. He owns half, I own half. If we don't say anything different in the deed that we receive, okay? If we are able to address the deed that's going to be given to us, the deed will ultimately say joint tenants with rights of survivorship, which that's the magic language. Now, there's some magic there that does work. The magic language would be the rights of survivorship. So if he passes, his half goes to me, and vice versa. That's about the only way a spouse is going to automatically get the other half of the property. Now, if somebody has no decedents, I'm sorry, no descendants, no siblings, no parents, they will, then the house may go to the surviving spouse, but that's unusual. Okay.
Okay. Well, next question actually is in the same vein. This person's in a second marriage, and in the divorce, the first um, the first wife and the person writing this split two properties that they owned, but the former wife's name is on the mortgage and will probably be on the title and deed. Does the second wife inherit the property by community property rights, or does the will need to identify who receives the property?
Okay, first of all, let me kind of go to the last question first. The second spouse is not automatically going to receive your half of the house under community property rights. I think I just made that clear with what I was talking about. If the first spouse was on the deed, and when I'm talking about deed, I'm talking about the warranty deed, the title that passed the property to you when you bought the property. If that person is still on that deed, it probably was addressed in your divorce decree. Check your final divorce decree to find out whether or not that has been addressed. And if it wasn't addressed, no, just come see me because that's a mess. Or go see any attorney and get that fixed. If the person, there was another question in there at the beginning. What was the second? They asked about, oh, on the deed, on the mortgage. He was saying, he or she was saying that their ex-spouse is still on the mortgage. That has nothing to do with ownership. That just means your ex-spouse still has to pay the mortgage if you don't. That's all that means, because that's a contract between you and the finance company who gave you the money. Okay, but the deed should have been handled in your final divorce decree.
Okay. Next question. I haven't done a will yet because I need to leave because I want to leave everything split evenly to my kids. And if they've already passed away, then split evenly to their kids. My kids don't have children yet, so the grandkids cannot be named. Is that a problem? And can I word my will to do as I've described above, even though the grandkids haven't been born yet?
Absolutely. Yes, we can make that happen. I do have language that I can insert that makes it very, very clear that any future grandchildren, or future children, if you're young enough, will be definitely part of the beneficiaries, and it will step down accordingly from your children to their children if they're deceased, etc. If you want to leave certain amounts of money to unnamed grandchildren, that's a little harder, okay? But if you want to make sure that anything that would have gone to your children will go to the grandchildren, we're in good shape for that. So,
Hey, somebody also wants to know if fill in the blank wills, such as those drawn up with LegalZoom or another online service, um, you know, what is, are those considered fill in the blank, like legal, those online services? So you went
yes,
to, you're
yeah.
asking people to avoid those.
I'm asking, begging you to avoid those. I'm not saying that they're all bad. There might be some out there somewhere that they actually took the time to make it relevant to you, but usually you're asking a series of questions that don't necessarily address your issues in a fill in the blank will. First of all, the courts say that if a will is half typed and half written or partially written, if you can look at the will and take either the written portion or the filled in portion all by itself and make some sense of it, we could use that as a will. God, don't rely on that. Just don't.
Okay, we are at time, but let's try to press on for as many as we
Mhm.
can fit in. When you file a will, do you file a will when it's prepared, or do you wait to file it until the person has passed away?
You can file a will with the county that you live in at the time that you do the will. You can file it with the county. It requires a little bit of a ceremony. You have to go and sign things and sign affidavits and show your ID and all that kind of stuff. But you can file it ahead of time. I have a lot of people that do that, and or ask me to do it because they maybe don't want their kids destroying their will, or there's animosity amongst the kids. You don't have to do that though. If you wish to, yes, you can. And then when you pass away, make sure somebody knows, and hopefully your attorney will get word that you've passed. Make sure somebody knows that that's been filed at the county, because then all we have to do is prepare the application for probate of the will and ask the court to go get it from the county clerk. Okay.
Okay, someone said that they've been told that probate in Texas is easy, does not require an attorney. However, you were saying that it does. Is it a must or is it just recommended?
To go to court to probate a will, it does require an attorney. That is not something you can do without. To prepare an affidavit of heirship, it's possible that you could do that without an attorney, but make sure it's not a realtor, make sure it's not a broker that's helping you, or a wholesaler trying to sell your house. Don't do anything that has legal ramifications for property or money without checking with an attorney. Even if you don't use the attorney to prepare documents, just please get some advice.
Okay. This person lives in Texas. They're an only child. Their parent is still living, and their parent has no real property or vehicles, and all liquid assets have a beneficiary. Personal property is less than $1,000. Do they still need to probate?
It
And if
might
so,
be
what?
that it might be that they don't have to. However, are there going to be creditors? Because you are still responsible. Somebody in the estate has to be responsible for paying creditors of the estate. You can't avoid that responsibility. So if you've gotten everything all taken care of and the assets are going to move to the beneficiaries, make sure, because the probate process is also about paying creditors appropriately, make sure there aren't any creditors out there that could open an estate on your deceased person and sue the estate for the money that they're owed. In other words, so if you have a beneficiary who says, "Oh, I got $200,000 out of their 401, but I wasn't the beneficiary, but I proved blah blah," and they have a creditor out there of a medical or IRS debt or child support, delinquent child support, things like that, they will come after you and they'll take it back out of your pocket, have you reverse that situation if you've taken the money. Um, Secured creditors get their cash out of an estate before beneficiaries, always. So beneficiary can't say, well, it was mine. Well, maybe it wasn't legally. So we want to be very careful that no creditors are left. So yes, you could avoid going to probate at all or even doing anything to probate the estate. And if there's already been a transfer on death deed for the house, things like that. That's might put you in a good place, and that does happen sometimes. But you got to keep in mind that it's about creditors too.
Okay, and does it matter whether or not in the person's case that we've been talking about, if there was a will or if there was not?
Oh, no, it wouldn't matter in that case. A creditor has the absolute right to go after an estate. So if Jane didn't open an estate for her mom, Mabel, if Mabel had any debt, um, a secured debt, some unsecured debt may fall into that too. HOAs, for instance, if you took possession of the house but didn't pay the HOA or the taxes, they're going to come after the estate. They can even open a probate for that if they want to. They are considered an interested party. So they do have standing to open a probate.
Okay, is final expense insurance a good option for an easy burial in the event money gets tied up in probate?
Ask that question again, please.
Is final expense insurance a good option for an easy burial in the event money gets tied in probate?
I don't know what that is. That must be a new product people are selling. Is that being sold through funeral homes, do you think?
I have no
Okay.
idea.
Final expense. That's interesting. I haven't heard that phrase before. If it's coming from a funeral home and you're trying to plan a funeral in advance of someone's demise, I think that's a very smart thing to do. It takes the onus off of your family to have to come up with all this money at the last second, unless you've got money laying around to pay for a $20,000 funeral. Trying to prepare for funeral expenses in advance is very, very wise. I've done it. My husband and I have done it because we just have one daughter, and it makes perfect sense not to give that to her to deal with. And think about it, when you die, you've only got a couple hours to figure out what you're going to do. This isn't something you just put off until you're done grieving. You have to take care of this, and you have to take care of it soon. I suggest that everybody check into that, but be very careful about who you're talking to about it, if it's a funeral home or Neptune Society for cremations, things like that.
Yeah, it's actually called burial insurance.
Oh, okay, okay. If it's not through the actual funeral home, be careful. Be careful. Make sure it's affiliated with a particular funeral home. Be careful about those. Yeah.
Okay, and the last one, so we're not too far over, is I understand the executor is legally liable for any mistakes he or she makes. Is that true? And how can the executor protect himself from this liability?
Yeah, an executor is if they make some willful mistakes or commit fraud or self-dealing, yes, they are liable. But if the executor is just taking care of the estate assets and they're accounting to the people who have asked for accountings, the executor is not the one who's responsible for what is going on in the estate. So, for instance, if there's a secured creditor who wants to get funds out of the estate, but there's no money left in the estate, that is not the executor's responsibility or the administrator's responsibility. The executor is there to move things along. The only thing they're responsible for are their own actions, legal or illegal.
Okay. Okay, great. Well, I think that is going to bring us to the end. We're only 8 minutes over. Thank you so much, Kathleen. We truly, truly appreciate your help with this
You're
series.
welcome. You're
And
welcome.
you've given us great information. Again, Kathleen Wiesenthal with Kiefer and Wiesenthal. And yes, you can watch this recording of this session on the HAPS YouTube channel or haps.org. And again, thank you so much. And thank you, Kathleen, and thank you so much to everyone for joining us today. We truly
Thank you.
appreciate it. Have a great day, everyone.
You too. Bye bye.
Bye.